May 28, 2025. Online news article published by the New State Time entitled Defamation Law. Sean Alipatek individual has talked about several issues regarding our defamation law in Malaysia. The former federal court judge has called out for a clear legal distinction in Malaysian defamation law, stressing that government, political parties and corporations shall not be allowed to initiate defamation suits against individuals. Originally designed to safeguard individual good name, the legal framework has expanded over time to shield the government as a whole, illustrated by two conflicted landmark decisions from the federal court in Chong Chen Jen and the state government of Sarawak, and another, the court ruled that government body can maintain a defamation action against a member of a public, yet in the Lim Lee Act and Ong Kang Chuan, the court decided that a political party is banned from bringing such an action. Despite contradiction in Malaysian jurisprudence, a political party is legally unable to sue for defamation while operating outside of power. But the moment it forms or joins the government, it instantly inherits the legal capacity to sue citizens for criticizing its administration. Consequently, government coalition can effectively utilize civil litigation to suppress public scrutiny, while the political machine behind them remains shielded. This issue is further escalated by legislative stagnation, as the Government Act, which is the Defamation Act 1957, remains unamended since its enactment, leaving it quiet on the modern mechanic of cyber libel and the social media.
Let us begin with the first case. The case of Chong Cheng Jen and government of the state of Sarawak arose from statement made by Chong Cheng Jen, a politician from the Democratic Action Party, or also known as DAP. In 2013, he alleged that approximately 11 billion ringgit of public funds had disappeared into what he describes as a black hole in the Sarawak government's financial administration. The Sarawak government and the state financial authority subsequently filed a defamation suit against him. A major legal issue emerged during the proceedings. Chong argued that a government should not be allowed to sue individuals for defamation. He relied on the Darwisy principle, a common law doctrine originating from the United Kingdom, which prevents governmental bodies from suing for defamation because such actions may suppress public criticism and democratic discussion. However, the Federal Court rejected this argument. The court held that under Section 3 of the Government Proceeding Act 1956, governments in Malaysia have the legal capacity to sue and be sued. Therefore, the court ruled that the Sarawak government was entitled to bring a defamation action against Chong Cheng Jen. The matter later proceeded to trial, and the High Court found that Chong's statements were defamatory. The court held that he failed to establish the defense of justification, fair comment, and qualified privilege. As a result, he was ordered to pay RM150,000 in damages and 50,000 ringgit in legal costs. This case is significant because it established that government entities in Malaysia may sue for defamation. However, the decision has also attracted criticism. Legal scholars and the Malaysian bar have argued that allowing governments to sue citizens may create a chilling effect on public discourse by discouraging criticism of public authorities. Therefore, the case highlights the tension between protecting governmental reputation and preserving freedom of expression in a democratic society. Now, let us move to the second case, Lim Lip Eng and Ong Kah Chuan. This case involved Lim Lip Eng, a member of parliament, and Ong Kah Chuan, who acted as the public officer of the Malaysian Chinese Association, or also known as MCA. Lim Lip Eng made statements during press conference concerning MCA's assets and finances. MCA subsequently initiated a defamation action through its registered public officer. The central legal issue was whether a political party could maintain a defamation suit. Lim argued that political parties should not be entitled to sue for defamation, relying on foreign authorities, which suggested that political organizations should be open to public criticism in the same way as the governments. The Federal Court disagreed. The court distinguished political parties from governmental bodies. It held that political parties are private organizations registered under the Societies Act 1966 and therefore possess legal rights and interests that may be harmed by defamatory statements. Since the law allows a registered society to sue through its public officers, the court concluded that a political party may bring a defamation action to protect its reputation. The court therefore answered the legal question in favor of Ong Kah Chuan and MCA, confirming that political parties have standing to sue for defamation in Malaysia. The significance of this case lies in its clarification of the legal position of political parties. While governments may sue based on statutory authority, as established in Chong Cheng Jen, political parties may sue because they are recognized as legal entities capable of suffering reputational harm. The decision reinforced the principle that freedom of speech is not absolute and must be balanced against the protection of reputation. In comparing both cases, we can see an important theme in Malaysian defamation law. The courts have adopted a relatively broad approach towards recognizing who may sue for defamation. In Chong Cheng Jen, the court recognized the government's rights to sue. In Lip Lim Eng, the court recognized the right of political parties to sue. From an academic perspective, this decision demonstrates the Malaysian court's emphasis on reputation as a legally protected interest. However, they also raise concerns regarding the impact on political criticism and public debate. Critics argue that allowing powerful institutions such as the governments and political parties to sue may discourage individuals from speaking openly on matters of public interest. In conclusion, both cases are landmark decisions in Malaysian defamation law. Chong Cheng Jen established that governments may sue for defamation under Malaysian legislation, while Lim Lim Eng confirmed that political parties may also sue through their registered public officers. Together, these cases illustrate how Malaysian courts seek to balance freedom of expression with the protection of reputation.
This journal studies the relationship between Malaysian defamation law, media freedom, and digital communication. It explains how the growth of social media and online platforms had significantly changed the way defamation occurs and how difficult it has become to regulate harmful speech online. The journal begins by explaining the meaning of defamation under Malaysian law. It discusses both civil and criminal defamation under the Defamation Act 1957 and Section 499 and 500 of the Penal Code. It also distinguishes between libel and slander and explains the three requirements needed to prove defamation. First, the statement must be defamatory. Second, it must refer to the plaintiff. And third, it must be published to a third party. The article highlights the role of the media and democratic society, especially in responsibility to inform the public and hold political leaders accountable. However, it also explains the tension between freedom of speech under Article 10 of the Federal Constitution and protection of reputation. A major focus of the journal is the effect of social media on defamation. Platforms like Facebook, Twitter, and TikTok allow defamatory statements to spread rapidly through comment, repost, and viral sharing. The journal discussed the uncertainty over who should be legally responsible, either the original poster, users who share the content, or the platform itself. The journal also analyzed major Malaysian defamation cases involving politicians, journalists, and online publishers. It discusses how investigate journalism can serve the public interest by exposing corruption, while sensationalist reporting may damage reputations unfairly. The paper uses examples such as the 1MDB scandal and Malaysia Kini, which is related case, to demonstrate this tension. Another important issue discussed is fake news and misinformation. The paper explains that the rapid spread of false information online has increased reputational harm and created challenges for Malaysian law. Although the Anti-Fake News Act 2018 attempted to address this issue, critics believe it threatened freedom of expression. The journal concludes that Malaysia urgently needs legal reforms to modernize defamation law for the digital age. It recommends clearer rules for online liability, stronger protection for responsible journalism, better fact-checking practices, and a balanced approach between press freedom and reputation protection.
Firstly, let us reiterate this issue, which concerns the intricate relationship between freedom of speech and the power of government in Malaysia. This issue has raised concerns as Malaysian courts allow government bodies to sue citizens for defamation, unlike the United Kingdom, where the Be Shire principle prevents governments from doing so. This strikes fear in the heart of the Malaysian citizens and discourages ordinary people from openly criticizing the government. However, the real question is not only about the problem itself, but about how Malaysia should move forward to create a fairer and more democratic balance. Firstly, Malaysia should reconsider adopting principles similar to the Libershire rule. Government institutions should not be allowed to sue citizens for defamation because governments are public bodies created to serve the people. In a democracy, criticism of the government must be protected, even when that criticism is harsh or uncomfortable. Public discussion and accountability are necessary for democratic progress. Now, necessarily, this does not mean individuals lose protection. A fair solution is to allow specific public officials, such as ministers or officers, to sue personally if false statements directly attack their individual reputation or accuse them of corruption or dishonesty. This approach protects personal dignity without giving excessive power to the state itself. Secondly, Parliament should consider introducing clearer legal safeguards for freedom of speech. Laws can be amended to ensure that criticism made in good faith on matters of public interest receive stronger protection. Citizens, journalists, activists, and even opposition politicians should not fear financial ruin simply for questioning the government actions. Thirdly, now courts should place greater emphasis on balancing reputation with constitutional freedoms. While reputation is important, freedom of expression is equally essential in a democratic society. Judges should recognize that criticism of public institutions is different from attacking a private individual. Governments are expected to face scrutiny because they exercise public power. And in addition to that, there should be stronger public awareness regarding responsible speech. Freedom of speech does not mean spreading lies or malicious accusations. Citizens should continue to criticize responsibly based on facts and genuine concern for public welfare. Democracy works best when both the government and the people act responsibly towards each other. In conclusion, allowing governments to sue citizens for defamation risks creating fear, silence, and an imbalance of power between the state and ordinary people. Democracy depends on open discussion, accountability, and the ability of citizens to speak freely about those who govern them. In Malaysia, there is no need to choose between protecting reputation or protecting democracy. Both can coexist if the law focuses on protecting individuals rather than government institutions. By adopting clearer safeguards for free speech and limiting the power of government bodies to sue, Malaysia can strengthen democracy while still maintaining justice and accountability.